Oh yay, oh yay, oh yay. The Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you very much. I apologize for the technical snafus. We have 3 arguments today, and this is the first one. So, of course, it's going to happen on the first one. We'll try to get it ironed out for this afternoon at least. My name is John Bailey. This is a great day for our court because for the first time in a very long time, we have a full complement of active judges on the court. This, in fact, is the first court session for Justice Bruce Williams. He joined January the 1st. Our other new justice joined the court on December the 3rd or 4th. His name is Stacy Trotter. Ordinarily, I'd say one is seated on my right and one is seated on my left. We don't have that luxury with oral arguments. I happen to hear some of the scuttlebutt. How long will this last when we do Zoom arguments? The intermediate courts of appeals follow the lead of the Texas Supreme Court. And it's my impression, I would think that we would be encouraged to continue to do oral arguments at least through September 1st. And I would not be surprised if it lasts longer. For us, appellate arguments are particularly amenable for doing Zoom arguments. Not so good for jury trials or things like that. So that's my 2 cents on how long I think this is going to last. So with that being said, we're going to proceed with our first case today. And I came up here and shuffled all my papers. And so first case up, it's cause number 11-19-250 CV, Dipprey et al. Versus Double Diamond et al. Mr. Shellhorse, are you ready to proceed?
I am, Your Honor.
Please.
May it please the court, counsel. My name is Brent Shellhorse, and I'll be arguing on behalf of all the parties, all the appellant parties today, including the association. These were the plaintiffs in the trial court. I want to step back and give everybody a big picture here, if I may. All the issues that we bring forward on this appeal have to do with control out at the Cliffs Resort development. And what I mean by that is we brought forward...
I hate to interrupt, but the clock's not running. Judge Bailey?
Yes.
There we go. Okay, never mind. It's running now.
Thank you. We brought forth the issue of the development period, which there's a dispute about whether or not the resort is still in the development period. The other side claims that it is, and that gives them the right to unilaterally change the rules on the homeowners out there. What I mean by that is the conditions, covenants, and restrictions on the property owners, and it gives them the right to change the size and the composition of the property. They do not have that control. We've set this out in the brief. They've put it in writing that this period needs to be revived, which suggests that they acknowledge that it doesn't exist. That's also plainly contrary to Chapter 209 of the Property Code that's necessary for reservation of a development period. So we've brought that issue. We don't think they have control to change the development. We've brought forth a issue.
Counsel?
Yes, sir.
What's your response on the argument that that's not a right matter to be decided since it hasn't been changed since 2011?
Your Honor, I don't think that is correct because even during the course of this litigation, when we were having a vote on the association, they tried to take some of the villas that were at the hotel and convert them using their power as a developer into timeshares so they could have extra votes for themselves during the election of the board of directors. So they even tried to exercise that right during this litigation. So I think it's right. It's definitely not a moot issue because it's still being used. They're still claiming they have that right. The other issue is the timeshare voting, which is what I just alluded to. That's a tool that they use to try to manufacture votes to create more votes for themselves to elect Mr. Ward and his cohorts, like Mr. Gracie, onto the association board so they can control the board. Fundamentally, what it is the declarations and the governing documents say 1 vote per lot. the timeshares sit on a lot, but they want to give each timeshare member who owns a week a full vote, the same as somebody that owns a single family residence on a lot. The problem is most of the timeshares aren't sold, so Mr. Ward can vote those unsold timeshare interests for himself. That is a control issue. We've brought forth an amenities issue. What that is, and reason that's a control issue, Your Honor, is because Mr. Ward, anytime his control is threatened or jeopardized by a property owner, he threatens them with denial of access to the amenities. He's done it out here with the marina and threatened to close the amenities. He did it at other resorts he owns, White Bluff. And so we've asked for declarations that we have certain rights, that our property owner's rights to use the amenities is not subject to Mr. Ward's whims, so he doesn't have that weapon. So why is control such an important issue? Well, I don't think you need to look any further than what happens when Mr. Ward is in control of the association. And he was in control for a little more than 2 decades, more than 20 years. When he's in control, he set up these 2 paradigms. One is a paradigm of a management services, where all of the association's revenue, its dues and other fees coming in, they know the association no longer has control of it. He gives complete control to one of his entities, Double Diamond Inc. or management. And they control the checkbook, who to pay, when to pay, how much to pay. They control everything. We also have a paradigm where he sets up a maintenance arrangement. Any maintenance to be done out at the cliffs, his entities have to do. Of course, there's no third-party bids obtained for that, and there's no price competition. He charges what he charges, and that gets deducted by his entities from the association's money and paid to him. You'll see when we were able to oust him from the board and get control, we hired third-party entities who provided greater services, equal to or greater services, than what he provided over the years. And you'll see that there's approximately, on an apples-to-apples comparison, about a $400,000 annual overcharge that was happening when he's providing versus third parties. But I really want to focus, if I can, on this management where they control the money. So he gives the control to one of his entities. And their corporate representative and their CFO of all the entities, Mr. De La Fuente, he testified that they've got ledgers that show that the association loaned out approximately $10 million to certain of Mr. Ward's entities. And those entities never paid back the association. But at the same time, other Mr. Ward's entities are purportedly loaning the association in excess of $10 million. Now, there are no loan agreements, no notes, no source documents for these tens of millions of dollars flowing in. When he's in control, he also transfers money out of the association to other resorts out of state. We identified $250,000 of this happening. $155,000 of that never made its way back into the associations until we deposed Mr. De La Fuente, asked him about those, and then the money magically comes back into the association's hands. It didn't stay there long, but it on paper, it came back in. When we asked him to explain, how can you have tens of millions of dollars flowing without any documentation? How can $250,000 go out of state and nobody raise a red flag or have a problem? The answer given is, well, these are all related entities and we're just treating them as intercompany transfers. But of course, that ignores the reality of the situation, which is the association is a non-profit entity. It's not one of Mr. Ward's entities. He never owned it. He never will own it. Just because he treated it like his bank account doesn't make it one of his related entities. You also have an example where once we were ousting them from the board and they were about to leave, we have $1.75 million in cash swept out of the account when they're being shown the door, so to speak. This is ostensibly to pay for loans made to the association sometime between 1994 and 1999. Again, no documentation, no source documents, no notes for any of those. They never went back to see if those were unpaid, accurate, anything like that. We even put into evidence resolutions where $1.5 million in association debt was forgiven in 2000 and 2005. Nobody checked to see if this was that same forgiven debt. Nobody even checked to see if that forgiven debt made it into the books of the association and given credit to them. So they just swept this money out the door.
Mr. Shellhorse,
Yes, sir.
obviously control of the organization is important to your clients.
Yes,
and,
sir.
and central to your appeal.
Yes, sir.
So with that being said, what's your position on what's proper method for vote tabulation?
So I think you're asking about the timeshare voting issue.
Yes.
And the timeshare voting issue says, Your Honors, that the declaration is the controlling document, you have subordinate documents. They're almost identical. But the declaration says you can have multiple owners of a lot. And each owner is a member of the association. So, but only one vote per lot. So a husband and wife who own a single family residence get one vote per lot.
Well, is there any conflict in the manner in which votes are tabulated between the declaration, the articles of incorporation, and the bylaws?
So I think all of them say that there's one vote per lot. They take the position because timeshare owners are members that they should get a full vote. But again,
doesn't the bylaws recite that a person with a timeshare estate interest would have a vote?
Yes, but again, that vote has to be agreed upon so that there's only one vote per lot if you read the entirety of that section. Just like a husband and wife, they don't get to have two votes. Or
not in my household, she gets both.
Yes, and that's the way the documents are written. And if you look at all of them, the controlling document says that, as do the other ones.
Mr. Shellhorse, while we're talking about voting,
I don't know who's talking. Is that Justice Williams?
Yeah, John. Yeah. How have votes been conducted since the trial? Is the board of directors, are they complying with the ruling that Judge Moore entered on how to tabulate votes?
Your Honor, I honestly do not know the answer to that question.
Okay.
It's
that's
not in the
fine.
record, and I don't know.
Sure. Okay.
The other thing I want to draw your attention to, if I may, is the resort allocation fee. We don't owe that money. There's no obligation, but it's a privilege, I guess. We get to pay for their expenses. We pay for their salaries of the people they employ out there. It's a subjective, fluid number. Over the last 5 years, it's totaled between about 1.4 or 1.5 million. So that's why control is important. That's why we need you to deal with the development period voting issue and amenity issues, so we have fair voting going forward. But the other relief we're asking for you is to correct the past conduct. And what I mean by that is what we've just described, this misuse of the association's money. We maintain that Double Diamond Inc. and Double Diamond Management owed fiduciary duties to the association with regard to the management of that money. The reason we take that position is the City of Fort Worth versus Pippin, the Texas Supreme Court case, numerous appellate decisions following that case and the logic of that case, including a 2006 opinion from this court, the Pascal versus Great West Drilling, that says, if you manage another person's money, you have fiduciary obligations. You have to account for what you do. You have to conserve the funds, pay it to only who's entitled to have it, and you have to segregate it. Don't commingle it with other monies. Trial court found that despite the case law, they had no fiduciary obligations. This created a second problem. It made us it shifted the burden of proof onto us to show that they failed to comply with some duty. They should have the duty because they were the fiduciaries and they were putting themselves in conflicts of interest. They were having transactions between themselves and related parties with a fiduciary. The case law is real clear in that situation. The burden is on them to prove their compliance. Here, as I said, the burden was shifted on us. Despite that error, I think we showed that they did not comply with their duties. First, they didn't account as you would expect a fiduciary. What they did was they produced what are called detailed trial balances. And those only go back to 2013. When our expert testified and their CFO, Mr. De La Fuente, testified, they all acknowledged that a detailed trial balance is not an accounting because it's just a ledger that contains summary entries. And there's nothing on those summary entries. There's no source documents. They were not checked against the source documents. They were only assumed to be correct. And there's nothing showing that that expense is really an expense to be paid by the association. Mr. De La Fuente acknowledged that the detailed trial balances are insufficient to prove the funds were spent on what's written in the ledger or that the amounts were appropriate and appropriately charged to the association. It's just a ledger. We tried to get the source documents. What happened? We went through discovery and trial court assistance. Remember, hearken to the Raiders of the Lost Ark, the final scene, the warehouse with the boxes. We get 179 boxes out of storage, no indexes. They just randomized and they contain folders. And a folder was a vendor folder, ABC Supply, Walmart. And in that folder is all the Walmart receipts, not just for the resort in Palo Pinto, but for the resort he owns in Hill County, White Bluff, the one he owns in Texoma, the one he owns in Cleburne, the Retreat. They're all in there commingled. You can't identify what a receipt goes to, which resort. You can't determine it as a third party. Even if you found one that said Cliffs on it, they testified when they would go buy 100 bags of fertilizer, they wouldn't buy 100 bags for the golf course, which we have the obligation to maintain. They'd buy 100 bags and some would go on the golf course and some might go to their hotel on the resorts. And so you couldn't figure out how they should have been allocated or how they were allocated. And that is not an accounting required of a fiduciary. And the gamesmanship they played with discovery, they didn't comply with their discovery obligations. And even the detailed trial balance admitted into evidence didn't reconcile with the financial statements they provided. And when we raised that at court, their explanation was, well, those actually covered slightly different periods. And if we'd have given you the matching documents, trust us, they would have all matched. They would have all balanced. But that's the accounting or absolute lack of accounting they gave us. As fiduciaries, that failed to meet their obligation. As far as payment and conservation of payment, here was their accounting system. The Double Diamond entities related to Double Diamond Inc. and management who are in control of the money, those other entities self-determine what they want to do and what they're going to charge. They then submit it to Double Diamond Management or Inc., depending on the time period. There's no verification that the work and materials actually provided, no verification of the amounts or expenses, no verification whether or not an allocation should occur, did occur, or how it occurred, no verification that the money was actually for an association obligation. Instead, what happened is you have transfers out of large round numbers, $100,000, $150,000, with no references being made out to other Double Diamond entities by Double Diamond Management, Double Diamond Inc. Our forensic accountant said this is a badge of fraud with these large, even-numbered round transactions with no corresponding data. So that's how they did it. So why is it a breach? Well, the loans, tens of millions of dollars of loans flowing out of a nonprofit to Mr. Ward's for-profit entities and money apparently flowing in, if you believe them, again, completely undocumented. That's association money not being conserved and being given to somebody not otherwise entitled to its use. You have the same thing with the transfer to the other resorts out of state. The $1.75 million, nobody was entitled to that. At least they certainly didn't prove it entitled to it. Matter of fact, because there's absolutely no documentation to this, that loan is unenforceable under the statute of frauds. A loan from 1994 with no documentation that supposedly grew in 94, 95, 96, 97. They have no documentation for it. There's a statute of frauds problem, Your Honor. That was unenforceable. The resort allocation fee, the one between 1.4 and 1.5 million dollars that they paid out when there's no obligation to pay it out, that is a misuse of the money favoring Mr. Ward and his entities. And
Counsel?
Yes.
At what point does limitations come into apply when you're referencing things from the 90s?
Well, I think it applies to, I think it does apply to them because they were in control of both sides of the equation. I don't think it equally applies to us because Mr. Ward was in control of the association for 2 decades, and we couldn't see the books and records, and we couldn't see what was happening until we actually got control into this litigation.
Does the discovery rule apply to a limitations defense?
I think it probably does, and I think, if I recall, Your Honor, we pled that as well as concealment.
So discovery limitations applies to one party but not the other?
Given that discovery is often, sometimes when a discovery rule applies, facts and knowledge of facts are involved, yes, Your Honor, because they controlled the documents, they controlled the paperwork, and if they're going to claim that we are entitled to payments from the 1990s, they should have known that that was due long before the limitations period. But we should not equally be charged with knowing that they did something wrong in 2007 when we don't have access to any of the information and can't get it from them. So I think there could be differences here. But as far as Mr. Ward and Mr. Gracie's fiduciary obligations, they're on the board. They have no management oversight. They turn it over to Mr. Ward's entities, do nothing to protect the interests of the association. And why? Because every penny is coming out of the association funds into Mr. Ward's entities in his back pocket. I see that I've got 9 seconds left.
No, you're past due.
Oh, I'm
12
sorry.
seconds.
Sorry.
But thank you very much. You'll have some time for rebuttal.
I understand. Thank you. And you want me to mute now, right?
Yes.
Okay.
Mr. Stoley.
Thank you, Your Honor. May it please the court. I'm Scott Stolley, representing the appellees. I can imagine that the court is sitting there right now thinking this case is daunting. And I think it's fair to say this case is an elephant. But the way you eat an elephant is one bite at a time. That's what Judge Moore did in this case. He methodically worked through dozens of pretrial issues. There were dozens of motions, at least 18 hearings. And you know what? The plaintiffs were consistently winning those pretrial motions. And then trial happened. And Judge Moore saw what was in the evidence and what was not in the evidence. At the conclusion of the trial, he spent over 100 pages on the record, methodically going through each count in the petition and ruling on each count. Again, he took it one bite at a time. Judge Moore made an extraordinary effort. He did what trial judges are supposed to do. And then he entered 50 pages of findings and conclusions. This court should not disturb what Judge Moore has so painstakingly accomplished. Enough resources have been spent on this case, and Judge Moore should be affirmed. Now, how do you get there? My brief gives you the roadmap for eating this elephant. I can't walk you through every bite, but I will try to focus on some of the issues that plaintiff's counsel has raised. On the issue of timeshare voting, the controlling language is in Article 4 of the Declaration. The second sentence controls. It says members shall be entitled to one vote for each lot or timeshare estate in which they hold the interest required for membership. It says one vote per lot, one vote for timeshare estate. The phrase timeshare estate is defined in Article 1, Section 11. It means any undivided freehold interest in a timeshare unit. So the document clearly differentiates between a timeshare unit and a timeshare estate. A timeshare unit is the physical space, the condominium space. A timeshare estate is the 50 weeks for selling weekly increments for the timeshare unit. So the document very clearly says each timeshare estate gets one vote, not each timeshare unit. Now, the plaintiffs try to muddle this by focusing on the third sentence, which is not controlling. That sentence starts with, when more than one person holds such interest in any lot or timeshare estate. So it's premised on, what do you do if more than one person owns a lot or a timeshare estate? Example, a husband and wife might own it jointly. It goes on to say, with a lot, what has to happen is those people need to get together and decide how to cast their one vote. Now, the plaintiffs glom onto the fact that this sentence doesn't mention, what do you do with multiple owners of a timeshare estate? It is silent on that. But that silence doesn't take away the governing language in the second sentence that each timeshare estate gets one vote. So that is still in there. If the silence creates any problem whatsoever, it's cured by the Article 4 in the bylaws, which is the same wording, except timeshare estate is added in two places to make it clear that multiple owners of a timeshare estate must get together and decide how they're going to vote their one vote. Basically, the plaintiffs are complaining that it's not fair. Well, it's not a court's job to judge whether a contract provision is fair, according to some parties' view of the contract now. The wisdom and fairness is not for the court to decide. In fact, there is merit to the idea that timeshare estates should get a vote because they are full members. They should have a say in what goes on. And they also, when they drafted this, they could have considered the difficulty of getting 50 timeshare estate owners to decide how to vote, one vote for a timeshare unit. And they decided that was impractical, and they put it in the way they did.
Sir, who drafted all of these documents? The declaration, the articles of incorporation, and the Bible? Or were they drafted by different individuals?
I believe they were originally drafted in the 1990s by someone affiliated with Double Diamond. There is also an ambiguity issue here. The judge said in his post-trial rulings at 15 RR 140, he used the phrase possible ambiguity. So we have a deemed fact finding here that any ambiguity is resolved in the defendant's favor. The final thing I will mention about voting is there's no harmful error here for the court to remedy. There is no complaint right now. They are in charge. And they will probably stay in charge because there are 2,400 lots out there versus 2,000 timeshare estates. So the lots have the ability to control. There is no harm for this court to remedy. Judge Moore got this one right. On the development period, this is purely a question that Judge Moore decided he should not rule. He declined to issue a declaration. And he was within his discretion not to issue a declaration because this issue is hypothetical, contingent, advisory, and non-ripe. The issue is, can Double Diamond unilaterally amend the CCRs? The trial judge was within his rights to say, in my discretion, I'm not going to rule on this because I don't have a concrete controversy right now before me where Double Diamond is trying to unilaterally change something in the CCRs. So he was under no compulsion to issue a declaration. And then if you look at the plaintiff's argument is, well, the developer cannot reserve this right because a statute was later passed. Well, that later statute cannot retroactively change in the rights of the developer. If that right exists, that statute cannot constitutionally change that. The judge was within his discretion to decide, I'm just not going to dive into this. I don't need to right now. If something comes up later, the parties can deal with it at that point. Regarding the issue of the amenities, the trial, this argument by the plaintiffs is premised on the idea that if they're denied access to the amenities, they need a declaration that they have an easement or a license and they cannot be denied. The trial judge made express fact findings and conclusions that there had been no denial of access. The plaintiffs have never challenged those fact findings or conclusions of law, so they've waived any effort to change that. The trial judge was also within his discretion as the fact finder to look at this evidence and believe there's nothing here that rises to the level of a denial that requires me to step in at this point and issue a declaration. So I'm going to exercise my discretion and not issue a declaration. But if you were to look at the merits of that issue on the amenities, they cite to a paragraph 2.04. Now, all that paragraph says is that residents at the POA, quote, may use, close quote, the amenities. It says they may use them. That language does not constitute the creation of an easement or a license. The judge was within his discretion to find that. Also, that section 2.04, that's a reference to 3 different documents that create a timeshare regime solely for 3 buildings. There's no evidence that any of the plaintiffs in this case fall within those 3 buildings and would have any rights whatsoever under section 2.04. So the trial judge did not have to issue a declaration here. He expressly said, if a problem comes up where somebody's denied an amenity, you come back to court, you come back to me and we'll deal with it then. He was within his discretion to do that. Now, a lot of the argument that you have heard, Your Honors, is a repetition of a jury argument of complaints about how this trial went forward and what the evidence was. On the issue of fiduciary status, this is really important because they're trying to use this to alter the burden of proof. Before trial, the court granted a no evidence summary judgment, finding that Double Diamond was not a fiduciary. This summary judgment was never withdrawn. The trial judge said this in his post-trial rulings at 15 RR 96 and 114-15 that the summary judgment was still in effect. The plaintiff's briefing does not have any argument within it about this summary judgment. There's an issue statement, but no argument to undermine this summary judgment. They don't cite to any evidence in the summary judgment record to demonstrate there was a fact issue that would have precluded this summary judgment. So the summary judgment is in effect when this trial goes forward, and the judge said it was in effect even after the trial. That's why there couldn't be a trial by consent of fiduciary status, because when there's a summary judgment, that's it. There's no issue to be tried. And counsel also told the trial judge that the evidence that they claim creates a fiduciary status needed to come in to demonstrate their breach of contract claim at trial anyway. So when evidence comes in for another purpose, there can be no trial by consent of an issue that's off the table. If the court were to look at the merits of the fiduciary status argument, it's important to understand the plaintiff's counsel told the court that there was a fact issue whether Double Diamond Management was an agent of the POA. This is at 8 RR 17 and 39-40. They said there's a fact question on agency. They premised their fiduciary argument on agency status. This means that there is a predicate deemed fact finding that there was no agency status. And this deemed fact finding is never attacked in the plaintiff's briefing. So what that means is no fiduciary status here. Even if and also if you look at the law of agency, the trial judge could easily find that there was no agency status here. This has to do with the service agreement. It's a 3-page document. It says nothing about fiduciary status. It does not create fiduciary status. It does not even create agency status. It is a service contract. We perform services in exchange for payment. The judge was within his rights to find that's all there is here. There was no evidence of agency, of agreement to be an agent, appointment as an agent, control over an agent, etc. And I'm going to take issue with one of the premises of their argument, which is Double Diamond was in charge. That's not true. The POA board is in charge. The POA board is the governing body for this association. Double Diamond is just an independent contractor working for the POA board. So it's not accurate to say that Double Diamond controlled everything. No, the POA board controlled it. Basically, what they're trying to say is they're trying to create this whole new common law category that if you ever touch somebody else's money, you're their fiduciary. There are no cases that create this category. The cases that they cite are cases that involved established fiduciary type relationships, such as an escrow agent, or deal with other issues like an informal fiduciary duty, or contracts where a fiduciary status was expressly stated in the contract. That does not occur in this contract. So it's just flat simplistic to say that there is fiduciary status merely because they handled somebody else's money. That doesn't create support the creation of a fiduciary obligation, which, as you know, the courts do not lightly create in a business setting. Regarding all of the allegations about how money went in and out, how the accounting was done, the judge heard hundreds of pages of testimony about this. He got to look these people in the eye and hear them explain what went in, what went out, how the accounting was done, and he could form his own credibility determinations about are they telling me the truth when they say the accounting is all on the up and up? That was within his role as the fact finder here. Now, even if there's fiduciary status here, a fiduciary burden is shifted only in 2 instances. One is when the fiduciary profited or benefited, and the other is if the fiduciary's self-interest might have conflicted. You need predicate fact findings to establish if either one of those occurred in order to then create burden shifting. On the first one, whether Double Diamond profited or benefited, the trial court expressly found Double Diamond did not. And there's no conclusive evidence to defeat these findings. On the other prong, self-interest that might conflict, there are deemed findings on this that there was no conflict, and there's no challenge to those deemed findings. So the burden didn't shift. Even when a burden does shift, it's only as to the fairness of the transaction. It doesn't shift as to causation and damages. This is in the Texas Bank case. Look at 595 Southwest 2nd at page 509. That's 595 Southwest 2nd at 509. So even under the worst case scenario that the burden shifted, it doesn't shift as to causation and damages. They still carried the burden to prove causation and damages by preponderance of the evidence. They don't challenge the actual and deemed findings of no causation and no damages proven by preponderance of the evidence. They have waived their challenge on that. Basically, what we have here is a bunch of assertions being thrown against the wall. I will take the example of the accounting. Was a proper accounting done? The trial judge was well within his rights in looking at this and say, you know what, this is the plaintiff's problem, that there is not every dime is nailed down because they didn't do the proper analysis. Plaintiff's expert at one point said, this is a monumental task, Your Honor. And the judge looked at him and said, so this is a monumental task that no one is doing, and you're asking me to do it. Well, he was well within his rights not to do that and to find that there was no preponderance of the evidence on any type of fiduciary breach. In conclusion, Judge Moore made correct legal rulings. He declined to issue declarations. When he did that, he acted correctly and within his discretion. On fact questions, those were his role to make, to judge the weight and the credibility. Under the standards of review, that evidence must be viewed in favor of the actual and deemed findings. So there's no reason to second guess him. As he had observed in his post-trial rulings, the plaintiffs are merely upset about the defendant's business model, and there's nothing illegal about that business model. Enough resources have been spent on this case. Please do not tell Judge Moore that he has to eat this elephant again. Thank you.
Thank you, Mr. Stolle. Mr. Shellhorst, we'll come back to you for a brief rebuttal.
All right, Your Honor, let me just go through these. The argument in a nutshell I heard was this is a big case. Don't spend your time looking on it. But that's exactly what you do as the Court of Appeals. So let's walk through those. The timeshare versus lot issue that's in the declaration. He says sentence 2 controls, but just ignore sentence 3. The fundamental question you have to ask yourself is, where a timeshare estate does not reside out in the ether. You know where it sits? On a lot. And the agreement says only one vote per lot, period. Either in the declaration or the bylaws. So that argument, I think you should dispense with. Besides that, this is no deemed finding. The trial judge determined that, in his own words, as a matter of law. It's how he interpreted it. So no deemed findings. The development period. Again, I told you they tried to exercise it to create more votes by converting part of the hotel. But this retroactive argument they made, in 2011, the legislature said, developers, if you want to reserve a development period, put in your documents how long you want to stake. They didn't do that. Instead, what they're saying is, since we haven't done anything, we might change the rules down the road and do it. We were not effective by that 2011 statute. That's wrong. The amenities and denial of access. Look in the record where they kicked us out of the marina at this because Mr. Ward testified, I didn't like that they were suing me. They denied access to the marinas, and the evidence is clear. They did it at White Bluff and they did it here. They even threatened to do it, and we had to give them money to keep it open during the course of this litigation. That's all in the record. The denial of access, they say there's no real harm or issue here. We can't access the agreements, but we have to pay our dues to the association, and the association has to pay to maintain all the amenities that the members can't use. Work through that logic he's arguing to you, Your Honors. The fiduciary status. He says that it was decided at summary judgment, but Your Honor, you'll see it in the findings of fact and conclusions of law. As the court knows, if it's going to be there, those are dispositive of the trial court's decision. It was tried. We raised an issue that he erred in granting the summary judgment on the morning of trial. We raised that issue. We tried it. All the evidence came in. He put findings of fact. We challenged those. So whether you think he decided it as far as summary judgment or evidentially during the trial, we did not waive that argument. He tells you that we want to create new law on handling somebody's money. I invite the court to look at the cases that I have cited to the court on the fiduciary obligations that already exist when you manage somebody else's money. Services for payment, whether it be an escrow arrangement or anything else, when you control another's money for payment, which they got, those duties are implied. We're not creating it. It's been in Texas law since the 60s. This monumental task argument that he says the expert made, let's put that in context. The expert was testifying that it was a monumental task to try to figure out where the money went when you're looking through 179 unindexed boxes with vendor folders with no way to figure out what resort they belong to, and that a third party like him could not do that. In fact, the evidence shows when we got the documents, we couldn't take them with us, we couldn't take copies, and we couldn't photograph them, take copies, or take the documents. So a monumental task in this production had to be done in that room and that day. That's the context in which that argument was made and was presented to you. On whether or not a fiduciary relationship exists and the predicate facts, we challenge that and the predicate facts, both that it exists because they're absolute control, the predicate facts that they had conflicts of interest, they were misspending the money. And on the no causation and damages, I think we've more than proved that you're transferring money without documentations from a nonprofit entity to your own entities and not paying it back, that you're transferring money to other resorts and not paying it back. Are we frozen? Justice Trotter, you're moving, but everybody else seems frozen.
I think, well, maybe I'm the only one that has a pulse now, but I think the clock stopped. In fact, you're over time by about 30 seconds, but I'll let Judge Bailey make that determination as to whether we need to cease your submission.
All right, I see him moving now.
Okay.
Judge Bailey, I think you're muted.
Sorry about that.
I apologize. I kept going. I wasn't seeing the clock wasn't moving either.
No, that's fine.
Sure. It froze at 18 seconds. So if you could come up, we've got 32 on there. If you can bring it home, we'd appreciate it.
Well, actually, I think it's 32 seconds overtime.
Oh, okay. Okay.
Because it froze at 18 seconds with 18 seconds left in rebuttal. And
were y'all all able to hear the last 18 seconds of the argument?
No. Yes, and it was great. No, I'm joking. We couldn't hear the last 18 seconds. Everybody froze and it went quiet.
I heard it, and I'm going to have the recording sent to both of them.
All right.
Okay.
Okay. I do have a question, though.
Yes, Your Honor.
And it was on the timeshare versus lot issue.
Yes, Your Honor.
Can you tell me a Texas Supreme Court case in which, since 1991, the Texas Supreme Court has found that a contract or a document is ambiguous?
Ask me that question again.
Yeah, there can't be an ambiguity in whether there's on the timeshare versus lot issue. We've got to harmonize the document or documents, and we have to come out with a.
I think you froze on me. Actually, he's gone. Justice Williams, he's gone.
I'm the only one with any good reception. So
There he is. He's back on my
there you
screen.
go.
Okay. Okay. Is it a matter of law?
Is the interpretation a matter of law? Is that what you're asking?
Yes. Yes, sir.
I believe it is an unambiguous document. Yes, Your Honor.
Okay. Okay.
All right. I apologize for the technical snafus, both at the start and at the finish. Your case has been submitted. If you'll both stay on with us for a second, Ms. Williamson will come on and conclude court. Court will be in recess after that, though, until approximately 11:10.
And so once she adjourns us, we're free to leave.
You're free to leave. Yes, thank you.
Your Honor. Scott, are you there?
I'm here, you're here, but they're frozen again.
Right.
Looks like they're asleep. Just for the sake of time, Judge Bailey has mentioned that your case is submitted, and I would suspect that had there not been a frozen image, Ms. Williamson would have adjourned the court. So I'll just consider this matter adjourned, and you're free to disconnect, or if you'd like to stay on, you're certainly welcome to do that as well.
All right. Well, all right. Thank you, Your Honor.
Okay.